I'm Claudia St. John. I'm president of Affinity HR Group, and I have on the line with me Charlotte Jensen, who is our VP of Compliance, who is in-depth knowledge of all the content that we're going to be talking through today and can really talk to the specifics in a great level of detail. Are you there, Charlotte?
I am here.
Great, so we're all working. So a little bit about Affinity HR Group. We are a human resources consulting firm that works with trade associations and in particular their association members who by and large have the same HR challenges as much larger companies but don't typically have a robust in-house HR consultant or HR professional on hand. We cover such service areas as answering questions when they come up on an ad hoc basis or doing recruiting and selection for, say, sales professionals or senior management professionals. We help companies with their compensation policies, and we also help with organizational development and general HR compliance. Before we go any further, I want to say thank you so much to Tricia and Kevin Gammon-Lee and Chris Ballman and the folks at Smith Buckland. For those of you who don't know, Smith Buckland is an association management firm that is premier in association management. We work with many trade associations, many of whom are associations that are part of the Smith Buckland family of associations. But we also have many non-affiliated participants as well that are either part of our strategic partners. So for example, they might be part of a large application tracking system or part of our own client base, not affiliated with Smith Buckland but affiliated through their own associations. So a very big audience today and a very diverse group, and we would not have been able to pull this off without the efforts of Tricia and Kevin and the folks at Smith Buckland. So a big shout out and thank you to them for doing this. What we're going to be talking about today is the changes to the overtime provision. This is a change that was announced in May, and we had been awaiting it. They first said that this was going to be coming out last year. The change is part of the regulatory responsibility of the administration. So the administration and the Department of Labor have oversight, according to the Fair Labor Standards Act, over the administration of this part of labor law. As a result, this isn't subjected to congressional approval or anything of the sort. So it really is just something that can be done unilaterally by the administration. That said, there are some attempts and some efforts now to perhaps affect it, which I'll ask Charlotte to speak to in a second. But as it stands, the changes that we're going to be talking through today are effective December 1st, 2016, so right around the corner. Charlotte, what do you hear about in terms of challenges or thoughts to challenging what's been put in place?
Yeah, there were two pretty substantial lawsuits filed just this week. One being 21 states came together to file suit against the changes, and that would predominantly affect public employees. And also the United States Chamber of Commerce, along with about 50 associations, filed a suit as well, challenging that some of the changes that have been made reach the oversight of the administration that go beyond what they can do without congressional approval. So far, the experts that I've read and talked to don't know that there's going to get a whole lot of traction on these lawsuits, but even if they do, you're looking at just over 2 months before these changes are to go into effect. So we have to operate as though no changes will occur. And my guidance to clients has been, even on the off chance that something does happen with these lawsuits that slows something down or alters part of it, this is still a wonderful opportunity for employers to not so much thinking about the salary piece, but thinking about the other side of this law that we'll talk about today, which is determining whether or not their employees are even classified appropriately as exempt or salaried, as we like to think of it. So this is a great time to do a good gut check in the organization anyway, even if something changes on this front. But at this point, it's may not be likely and definitely too soon to say.
And I will say that a couple of the associations that are on this call today were part of a party to the lawsuit against this rule change. That said, notwithstanding those good efforts, we fully expect that this will be what employers have to comply with, as Charlotte said. So our best advice is proceed as if that's not going on, because you don't have enough time in case nothing comes of it. These are changes that are right around the corner. This is the second webinar that we've done relating to these changes. The first one we did back in May, soon after it was enacted, or soon after it was rolled out, and we held a pretty large webinar then and spent about an hour with your questions and answers. We provided about 30 minutes of content and then an hour of questions and answers. We only have an hour this time, given time constraints that we have with our format today. But if you go on our website, which is www.affinityhrgroup.com, in the sort of center of the page at the top where I've circled here, there's a little YouTube icon. If you click on that, it will take you to our YouTube channel, and you'll be able to access that webinar from May. It's the easiest way to find our YouTube channel, so if you're looking for additional content or just want to hear some more in-depth question and answer, that's a great place for you to go. So the basics. What the Fair Labor Standards Act, first of all, this was an act that was enacted back in 1938, and it basically covers the law, the labor law, relating to minimum wage, overtime, what constitutes hours, deductions, rules around child labor, and record keeping and payroll requirements. So this is the standard law that is a dynamic law. It's updated from time to time. It harkens back to that date, but it is the federal law that establishes. As a federal law, it sets the floor. It's the minimum. That doesn't mean that states don't have a richer level of law. For example, it establishes anything, time and a half over 40 hours. That's federal law. Some states have overtime, anything over 8 hours in a particular workday. So again, a lot of law is also administered on the state level. What it isn't, it does not regulate breaks, it does not regulate time off, or whether somebody should be full-time or part-time, or any considerations around that, maximum hours worked, or how frequently you pay wages, your payroll period, that sort of thing. None of this is covered by the Fair Labor Standards Act. A lot of this is addressed, again, by state law, but this is really the law that establishes these standards. What we want to talk about today, how it works today, is that the law, the Fair Labor Standards Act, and my thing is not advancing, the Fair Labor Standards Act today establishes that, and as it did then, that people should be paid according to the time that they work. So pay for all time worked, and anything over 40 hours within a pay period should be time and a half. That's the federal standard. And I am going to see what's going on here. Oh, there we go. So basically, any time that's worked, any time that you should be working, you get your time and then time and a half. So that's a normal person. That should be most of the workforce, and it certainly was when this law was put in place. However, there are exemptions to the Fair Labor Standards Act. So there are people who for whom this doesn't apply, and this is where the term exempt comes from. It means exempt from the Fair Labor Standards Act, which means that the actual tracking of time on a real-time basis and then awarding time and a half after 40 hours in a pay period doesn't apply to these people. There are 3 requirements for you to meet to be even considered exempt from the Fair Labor Standards Act. The first is that you're paid on a salary basis. For most positions, there are exceptions, but for most positions, to be exempt, you have to have a predetermined salary that is set, that does not change from time to time. It does not change based on how often you work or how much you work. It is your set salary, regardless of how much time you actually put in. The second is that you need to meet the salary level, which means that you have to have a minimum pay of at least $455 per week. That's today. What's changing and why we're all on this webinar today is that is what's going up. So it's going up from $455 a week to $913 a week, or $47,476 per year.
And Claudia, I often, clients will often ask me if a person is part-time and salaried, are these amounts prorated based on the, how much of a part-time person they are? Like, do they work half-time? And the answer is no. Whether or not a person is full-time or part-time, they still have to be paid the full $455 or now $913 per week as their minimum salary to meet
So
the
regardless of how much they work, they have to have a paycheck of at least this per week.
Mm-hmm.
Got it. So the three standards, one again, they need to be salaried. They need to earn at least, effective December 1st, $913, and their duties. The duties of their position have to involve executive, administrative, or other white-collar functions. This is a big deal because a lot of people think it's just the salary that they need to pay attention to, and that's not true at all. The duties test is perhaps the more stringent and the more important for people to be thinking about, and we're going to talk about that in a second. So I'm sorry, my clicker is not happy. So the Fair Labor Standards Act allows for some specific exemptions, and again, this is where we get exempt versus non-exempt to the overtime and pay provisions of the FLSA. And they are the executive exemption, administrative exemption, outside sales exemption, professional exemption, computer professional, highly skilled, and highly compensated professionals. Most of the clients that we work with, most of you on this call, the exemptions that you're typically using are one of the top three, either the executive, the administrative, or the outside sales. And so as a result, those are the ones that we're going to focus on right now in terms of what qualifies being exempt for that.
And there are also actually a few other real niche exemptions, such as in the motor carrier, first responders, but we don't need to go over those, obviously. But there are a few other random ones.
And Claudia, we just had a quick question come in about the numbers that you're using in the presentation. Are these figures gross amounts or net amounts?
They're gross.
Okay, great. Thank you.
Good question. So for the executive, remember there were three executives. There were three exemptions. There was executive, there was administrative, and there were outside sales, and those are the ones that we're focusing on. Again, there are more, but these are the ones that we're focusing on. For you to be qualified for the executive exemption, all of the following need to be applied. I apologize for my slide advancing. There's something very hinky going on, so my animation's not working too well. But the first is they have to be paid on a salary basis at least $913 a week effective December 1st. So that's the first thing that they have to satisfy. And now we get into the duties test. Their primary duty has to be managing the enterprise or managing some subdivision or department within the enterprise, actually managing it. They also have to direct the work of at least 2 full-time professionals or the equivalent of 2 full-time professionals. And the third, and this is the most important, they must have the authority to hire and fire employees or have the suggestion and be able to put the recommendation to the hiring, firing, advancement, promotion, or any other change. We see a lot of folks get things like the title of manager, the title of supervisor, and they think that that title allows them exemption under the executive exemption because they're managing others. But in fact, that title does not count. What counts is if they actually have the authority and the discretion to hire and fire, promote, demote, and are truly managing a division or subdivision. Charlotte, any addition to that before I move on?
Yeah, a lot of times working supervisors try to get lumped into this, and working supervisors are a tricky area. Assistant managers, because they may help manage the employees, but they may not have that level of authority to hire or fire, or they may spend so much of their time being a working supervisor where they're doing the same work that the employees are doing, that they're not truly managing the department.
Yeah. And we often hear, but you know, they sat in on the interview, so they're part of the hiring, or they sit in on the you know, the exit interview or whatever when you're letting somebody go, the disciplinary hearing. Being a part of that process does not mean that they have the true authority. So it really is the person, it's the, you know, to coin a phrase, the decider, if you will, who's more likely to qualify for this exemption. So for the administrative exemption, all of the following need to be met as well.
And you only have to meet the criteria. An individual only has to meet the criteria in one of the exemptions. So if you go through the executive exemption and your person fits the criteria, great, you're done. If they don't meet the criteria of the executive exemption, that doesn't mean they're not exempt. It just means that, okay, now I have to look and see if perhaps they meet the criteria of another exemption. But they only have to fall within one of the categories.
But however, so if you're claiming an exemption under the administrative exemption like we have here, you have to qualify, you have to satisfy all three of the bullets on this page in order to satisfy this exemption. But again, if you don't satisfy this exemption, you may qualify under another exemption. So the administrative exemption, again, you need to be paid on a salary basis, the new minimum of $913. Your primary duty must be the performance of office or non-manual work related to management or general business of the company, the operations of the company. So a lot of administrative staff would fall in that. But they also have to have the exercise of discretion and independent judgment with respect to matters of significance. So what this means is that they have to have the ability to make big decisions that could impact the company, such as engaging in a contract that is of significant financial risk or responsibility to the organization, being able to independently make decisions about matters of significance, or purchasing, for example, or pricing, for example, or structuring a workflow or a product launch or something that has a significant impact on the company. And this is the part of this exemption that many of the clients that we work with don't satisfy. For example, many customer service reps can qualify for the first two, but not this third bullet. Charlotte, any thoughts?
Yeah, one of the examples that I use a lot for this category is thinking about your pricing, individuals involved with pricing. You may have an individual who they have parameters to work with. They can quote prices to their clients, and they can go offer discounts, and they can go a little bit outside of the parameters. But for the most part, they are following pretty stringent guidelines on what they can offer a customer, and if they want to go too far outside of those guidelines, they need to get approval in advance. That type of person is typically not going to qualify as exempt under this category. However, the individual that goes out to market and actually analyzes prices, determines your prices, looks at competitor pricing, determines margins for profit, and that level of analysis and decision making that actually determines the overall pricing for the organization, that person probably does meet the exemption because of the level of significance and independent judgment that they have in performing those duties.
Excellent. So the third one is the outside sales exemption, and again, all of these have to be met. All right, here we go. First, the primary duties have to be making sales as defined by the Fair Labor Standards Act. So they have a definition of what making a sale looks like, and it probably looks like what you think it looks like. It's going out and basically soliciting work outside of the workplace, or obtaining orders for services, or basically out getting the work. But they also have to be engaged regularly away from the employer's place or place of business. So these are truly outside salespeople, and that's very different than an inside salesperson, which we'll talk about in a second. But it's a typical salesperson that you would imagine working on commission or commission-based, going out and engaging in obtaining orders for services or other products. But we see a lot of clients classify their inside salesperson, somebody who's receiving an order off of the internet, who's answering the phone, or is engaged in a relationship with a client, and then says, by the way, have you heard about this other product and service that we work on? Maybe you'd be interested in it. That is not an outside salesperson. For the outside salesperson, if they satisfy the first two bullets, they do not have the minimum salary threshold. So that's the one position where a minimum salary threshold does not apply for an exempt status.
They could actually be 100% commission, and that 913 is completely irrelevant if they are a bona fide outside sales professional.
Again, we talked about there were other exemptions: computer, professional, highly compensated. There's a lot of stuff. There's a lot of law and a lot of regulation over the years that have added up as these new positions emerge, as the world moved from industrial into office work. So if you have any questions, of course, we're happy to help you. But the first place I would go, and where we always go, is we Google DOL, which is Department of Labor, Fact Sheet 17. And there are a number of fact sheets from 17A to 17J which spell out the specific duties tests of all of these positions. What's so important about the duties tests is that this is really the criteria on which you make a determination whether somebody is exempt. That salary threshold, that's an easy test. You're either making it or you're not making it financially. But the duties test is the one where most of our clients are not making the right decisions, are not looking at the right pieces. They think it's their own discretion. They think they get to choose whether to pay somebody on an hourly or on a salary basis. Really, a lot of this is set in law and is set in you know, case history over the years. What is changing? So, as we've talked about, come on, computer. Go back. The minimum is going up, as we've already talked about. It's going to be $913 a week, or $47,476 a year. What's new is that in the past, that salary threshold has been adjusted periodically. So the last time I think it was adjusted was 12 years ago, and before that I think it was close to 20 years prior to that. Going forward, they're going to be doing an automatic adjustment every 3 years. So the next one is slated to go into effect in
January 2020 is when the 47,476, as it currently stands, will automatically be increased.
Go up. And there are details behind what they're going, how they're going to index it and what they're looking at, which we can talk to you about offline. In addition, this salary threshold, 10% of that salary can include non-discretionary bonuses or commissions. These are bonuses or commissions that are already set in advance based on certain achievements or goals or things that have to be met in order to earn this bonus. So if you take that salary, you take the salary plus the bonus, it has to earn, you have to be at least $47,476. That means that you can earn a total of $821.70 in bonus. So that means your base pay can be as low as $42,728 plus that $821 in order to get up to that 47,000 threshold. We're going to talk about that because that looks like a great idea for folks. Oh, well, then I don't have to pay that much in salary. I can add in that bonus, and then I can satisfy it. Not as easy as we think. We're going to look at that in a minute. And then the only other change also that came into place was that highly compensated employees, that threshold went up from $100,000 to $134,000. What didn't change? Importantly, the most important thing that did not change, if my computer will ever work, is the duties test. This is killing me. So there was no change to the duties test. It remains the same, and it remains the greatest area of risk for our clients. As we've already said, this is what people think, that they think that they have the right to make this discretion. But they're positions that, if you look in your own companies, if you are paying your customer service rep a salary, or if you're treating them as exempt, or your inside sales, or some of your supervisors and managers, admin support, administrators or analysts, those of you in the insurance or the pension and financial world, you should be looking at those duties. And you know, it is possible that you can have positions that are the same type of position, but one has more discretion, one has more authority. That could be exempt, and somebody with the same position could be non-exempt because they don't have the same amount of discretion or authority. Charlotte, when you're going in and doing work with clients, what do you look at in one of these positions? What do you look at to be able to say this passes the sniff test to be an exempt versus a non-exempt employee?
So much of it really does depend on how high-level work the individual is doing versus how procedural the work is, and back to that decision-making authority, how far beyond established parameters. Can this individual go without advance approval? Not having to have advance approval doesn't mean that they don't have oversight, but that they're allowed to deviate from prescribed parameters on their own in the moment. And also, even though we say the title doesn't matter, what matters is the duties, certainly looking at the title is a really great place to start, because the Department of Labor over the years has identified many positions, and that's why you see customer service rep, inside sales on this list. They've been asked the question so many times that they've already established opinion letters and documentation on why these positions historically are not exempt. So anytime I see a position that the Department of Labor has already discussed in the past, then that's a huge red flag. So it doesn't mean that a customer sales rep isn't going to be exempt, but automatically, because of the title, it certainly it makes you pause, and then I probably look at those duties much, much harder, because the likelihood that they're exempt is on the lower side.
And they've made those determinations for customer service reps and for inside sales, right? Those are two positions that we know pretty clearly typically are viewed or are viewed skeptically from a non-exempt standpoint, or from an exempt.
Yeah, and just to give everyone kind of an idea, sometimes when you hear some of the other categories that they've weighed in on, it kind of helps the whole process be clear. For example, a bookkeeper is typically non-exempt, whereas your accountant is exempt. A paralegal is non-exempt. An attorney is exempt. A cook is non-exempt, but a chef may be exempt. So you can see just in the comparison the level of decision making and authority and knowledge and skill that those positions have over the other.
Great. All right. So in talking with our clients about getting ready for this change, basically there's sort of two different alternatives that our clients have been looking at, and they're basically looking at their exempt employees who are below that threshold, and they're either deciding to increase the compensation in order to satisfy that threshold, or they're reclassifying them as non-exempt, and we'll be tracking their time and attendance, and they're eligible for overtime. So if you see this dollar sign, this is a symbol that we're using just to denote for people who are planning on raising up those employees to that new minimum threshold, versus the dude holding the clock. That's what we're going to be using to say this is the group of folks who are going to be reclassifying their employees, their current exempt employees, as non-exempt. So for those who are looking to increase their employee salary in order to satisfy the new minimum, they've got some basic strategies. So the first is to increase it to the new minimum, which again we talked about, $47,476. And what they're doing basically is that they're running their payroll. They're looking to see who do they have as exempt employees, and they're identifying those that are currently below the minimum, and they're increasing those. Most basic is they're increasing those who are pretty close, spitting distance, if you will, to the new minimum. And then they're converting those who are well below that minimum back into a non-exempt position. But they have some alternatives there, which we'll talk about. Those who are increasing them, up to 10% of the salary can be paid through non-discretionary bonuses of incentive pay and commission. The thing about that is that they have to be paid at least quarterly, and employers have only one pay period after the quarter to make up any shortfalls. So this is again what we were saying. If you're planning on paying them that lower salary of $42,728 and then making up the rest in bonuses, Charlotte, why might that be a scary alternative?
Well, for several reasons. One, at this point, we don't have a lot of guidance on the practical use of this. And when you think about it, the difference is pretty small. You're talking the ability to pay someone $821 per week versus $913 a week. So that's a pretty small margin, and it certainly increases the administrative burden, because now you have to, if you're not incentives at least quarterly, you've got to very quickly calculate them at the end of the quarter and have basically one pay period to make up the difference. The challenge we have at this point, because the practical application isn't out there, We have no guidance on what happens if an employee terminates within the middle of a quarter. We have no guidance on if the catch-up that's required is below the 10%, or excuse me, exceeds the 10% that's allowed. We don't know if each quarter stands alone. This quarter my employee didn't meet the requirement, so I had to convert them as non-exempt for the quarter, but can I take them back to exempt next quarter? We don't know. Also don't know if even if you're paying the incentives quarterly, do you have to apply this on a week-to-week basis? So, well, this week your commission was up, so you're good, but last week your commission was way low, so I have to pay you a catch-up or convert you to non-exempt. We just don't have the guidance yet on the practical application. And what I'm finding at this point is a lot of employers are deciding that the administrative burden, coupled with the relatively small amount that they can apply for this purpose, is out of whack to where it's not worth their while to do this.
It's not worth it. And the other thing is, if you have to convert them back to hourly, now you have to be looking at things like overtime and overtime calculations. So this could be a big pain in the neck, and I would only consider doing it if you're certain that you're going to have regular commissions that are easily going to bump them up over that $47,000 mark. But if you do, then I would consider maybe converting them to salaried and putting them up there anyway, as long as they satisfy the duties test. What can't be included in those salary calculations? Come on, computer. Go back, computer. Discretionary bonuses, such as boarding, and a discretionary bonus is, hey, you did a really good job on that, I'm going to give you some extra money. It can only include non-discretionary bonuses, which are already tied and formulaic so that you know what you have to do in order to earn that money. And it also can't include things that are non-regular income related, such as boarding, lodging, medical contributions, for other fringe benefits, and any other non-pay based calculation. So critical things to think about if this is the group that you're going to be, this is the approach that you're going to take, which is bumping people up to that new minimum, that you still have to satisfy the duties test. Even if you get them up to that minimum, you have got to check out that duties test. Employee misclassification is a huge issue, and here's the thing, you're only as safe as your last bad hire, and what I mean by that is every employee who's anywhere near this minimum threshold right now knows about this law. It is all over the place. It's not law, but this change. They've been seeing it in newspapers. They've been at the water cooler talking about it. They know that they're close to possibly being eligible for overtime. We don't know what they think about it. They may be happy about it or not happy about it, but they know that this is out there. So if you do make this change and they question it, it's too easy for them to go back and say, I was misclassified. I wasn't paid enough, or I was paid enough, but I was misclassified because my responsibilities should have kept me down below. So it's just a huge area of risk for you if you don't have that duties test buttoned up. So for those below the new minimum, those who are earning less than the new, well below the new minimum, the first is to reclassify them as non-exempt, pay them hourly, track their hours, and make them eligible for overtime. This is the standard way that people treat non-exempt employees. So very straightforward. You're hourly. Now you're going to track your time, and this is, you know, this is the new realm. And if you work more than 40 hours, you're going to get overtime for that. What's important for those of you who are new to this is that you need to learn what is compensable hours and what are not. And the Department of Labor and the Wage and Hour are very clear. There are a lot, just like some of these other things, there are a lot of rules or decisions in the past that specify what is compensable time, compensable hours, and what isn't included in that. And we'll talk about that in a few minutes. You also need to establish a very solid tracking system and record-keeping system. It's not okay just to say, oh yeah, they worked 8 hours every day, so we've got a total of 40. You actually have to be tracking that time and attendance. And you need to be clear about and be able to accurately calculate for overtime, which we're going to talk about that in a minute too, because again, an area of huge challenge for a lot of our members. Another strategy, if you're below the minimum, for those of you who are converting folks who had been exempt before and are now going into non-exempt, that can be a hit for them. That can be a hit for them. They feel sort of, you know, like they're now demoted, like all of a sudden their status and stature in the organization doesn't value it as much anymore. For those folks, some of our clients are looking to reclassify the employee to non-exempt, paying them a salary so that they still have that predictability in their income and not that much has changed. That said, they still have to track the hours and they're still eligible for overtime. So you may be paying them a salary, but some of that other administrative tracking and reporting and those calculations and the liability for overtime, that all still exists. So it's just taking one step forward. You know, you're non-exempt, but we're at least going to pay you a salary, but we still have to track that time, and if you go over 40 hours, then we're going to be paying you overtime, time and a half. And then the third strategy that a lot of our folks are considering is to reclassify as non-exempt. It doesn't matter whether they're paying them hourly or salary, but they're looking to restrict the work so that the workday is well below 40 hours. And that's basically done to avoid overtime. We know a lot of our clients, for example, that are in the automotive, oil change, car wash type industry or service sector industry, they might have, you know, a regular work week of 45, 50 hours a week. And given this new change to overtime, they're looking at maybe dividing those jobs into a couple of part-time jobs, really managing the time and attendance much more closely. So they're working very, very hard at that. Even still, if they do that, they still have to track their time, report their time, and get paid overtime. Charlotte, you want to speak for a second about unauthorized use of overtime and whether you can dock pay for that?
Yeah, and the answer is no. When clients ask about do I have to pay for overtime I didn't authorize, my answer is always that unauthorized overtime is a discipline issue, not a payroll issue. You still have to pay for the hours worked. You can't get out of that. But if you have a handbook and there is a policy in there against working unauthorized hours or unauthorized overtime, then you can enforce that as a policy violation and discipline for that just like you would any other violation of policy or conduct, but you still have to pay it.
So this has to be part of your regular performance disciplinary process, which would be in your handbook, right? So you can't mess with their pay if they go into overtime, but you can discipline and you know, hold them to the policies for getting it. So for those of you who are going to be new to hourly pay classification, to paying people hourly, it's always safe to classify people as non-exempt and pay them hourly. I mean, that's the least amount of risk because that's really what the law established, that people should be paid for the amount of time that they work and that they should get overtime for any time over 40 hours a week. But again, you must track the actual time. You can't just say 8 hours. It has to be an actual calculation of the time. You have to know what hours worked means, and you have to know how to calculate overtime. The greatest risk for our clients is involving the calculation of overtime because there are too many ways to get it wrong. And it's not as straightforward as we would think. We have an exercise that we're going to go through very quickly. We're already at the 40-minute mark. So, Charlotte, do you have anything that you're pressing on this that you want to talk through, or shall we just zip to the other piece?
Nope, go ahead.
All righty. So quick calculation, quick exercise. Let's assume that we've got somebody who's now earning $15 an hour, and this week he worked 43 hours, so 3 hours of overtime, and he earned a production bonus of 150. Okay, a typical person would go through this calculation. Come on back. This is not going to work because of my animation. Basically, what most folks will do is they go through and they just do the 40 hours at 15 to get them $600, and then they take the 3 hours at time and a half using that $15, and then they add the bonus, and that's the total time they come up with, $817. So they just take the straight time, then they add the overtime, throw in a bonus, and that's the earnings for the week. That's not correct. What they really should be doing, and I'm going to just put this up there and see what happens. What they really should be doing is, come on, killing me. What they should be doing is looking at the total hours worked at 15 hours. So the total straight time, 43 hours at 15 hours. and add the bonus in to come up with what the total straight time is, not taking into consideration the overtime, and coming up with what's called a regular rate. In this case, it's $18.49, not $15 an hour, but $18.49. And the overtime is calculated on that regular rate. So the overtime, which is $27.73, is based on that $18. That's the time and a half. So to calculate the total earnings for this person, you take their 40 hours at that regular rate, at that $18.49, and then you add your 3 hours of overtime at $27.73 to come up with a total of $822. Okay, so it's only $5 off, but it's only $5 off for one employee for one pay period. So consider the totality of pay periods and all of your employees. If you're not getting this right, it's a huge liability. And if you're not getting it right by mistake, they can go back and recalculate all of the overtime and lost wages going back 2 years and penalties and fines. Or if you knew you were doing it wrong and you were still doing it the wrong way, they can go back 3 years. So huge liability for not doing these calculations correctly.
And real fast, this is not new at all. This calculation has nothing to do with the changes coming 12/1. This has always been the way it is. It's just that most employers don't realize that. But if you actually look at the language of the Department of Labor, it does not say that overtime is based on time and a half of your hourly rate. It says overtime is based on your regular rate of pay. And Department of Labor specifically says regular rate of pay includes non-discretionary bonuses, such as production bonuses, things that if I do X, I will get Y.
And this is why it's very confusing. If you're thinking about using that 10% salary, 10% bonus part of the salary, and you should have to go back. They didn't make that 10% one pay period or one quarter, and you have to go back and recalculate them on an hourly basis. You have to go through all of this process, and all of those bonus productions have to be factored in to that regular rate of pay. So, again, not too confusing, but if you're not doing it right, huge liability. These are some resources for you. The Department of Labor, if you Google DOL and overtime, they have a lot of questions and answers and guidance for small businesses and private employers on this new requirement. So again, a lot of great resources out there, and we encourage you to go check that out if you haven't already. So I wanted to leave enough time. We've got 15 minutes to answer your questions, and I want to throw it open to your questions. Again, we're here to help whenever we can. I'm just going to leave it on this slide just so that you have our contact information. But Tricia, do we have any questions that have come in?
Yes, we do. So the first question is, can you please clarify the part-time salary test information?
What we were saying is that $913 per week is an exact minimum. If you've got a part-time employee that you pay salary, you cannot prorate the $913 and consider them as exempt. That even if they only work 5 hours per week, if they are salaried, they must make $913 per week minimum.
Great, thank you.
Yes, you're welcome.
Just to hit that point one more time, if you have somebody who you treat as a salaried employee, but they only work for you a couple of days a week, they truly are not salaried because they wouldn't satisfy that minimum.
And if they do work 2 days a week and are making $913 a week, I would like to come work for you too.
Me too.
So the next question is, are there any considerations for nonprofit organizations?
No, unfortunately.
There are certain exemptions. This doesn't apply to some public sector workforces, so these minimums don't apply in some instances, but again, not in all instances. So some public sectors, this does not apply to some public sector workplaces, but everybody else pretty much profit.
And this is one of the areas that I think has gotten hit the hardest and is going to be impacted the hardest over this change, because the vast majority of those employees would fall at a lower salary point, and they work long hours because they're passionate about the mission, but the law does not make any distinction between a nonprofit and a regular employee.
Okay. Referring to the admin exceptions, does or could a customer service 3 bullets of the admin exception?
You dropped out. Can you repeat that question?
Yeah. So referring to the admin exceptions, does or could a customer service representative meet these 3 bullets of the admin exception?
Oh, yes, I mean, I think so, and Charlotte, you can probably speak to it as well, but if you have somebody who, for example, has the opportunity to price out a project, or who has the opportunity, without guidelines, who can just go in and say, you know what, actually for you, why don't we discount this, keep that, and we'll send you this new model, and if it doesn't work for you, send it back to us. If they're making those kinds of discretions, I could see that they could, but again, they would have the complete authority to make those decisions.
It's a very case-by-case basis, and I would not make a blanket statement on a position like that, because they really, you know, if they're working with the most difficult clients and they're allowed to make decisions that bind the organization in contracts, that affect the margins that they're allowed to accept and things, then it might be, but it'd be an individual conversation.
And I think this is another important point, which is that in all of the duties tests, we go in and we really look at what that person's doing. And again, you could have a customer service rep that meets that exemption and one that doesn't. And that's part of the consulting that we do, and it's part of the offer that's up on this slide, but really you need to look at these specifically. You need to really look at the duties and how much discretion they actually are able to extend. And that's why it's important to really get this stuff buttoned up.
Great. So another question, in our industry, night managers do a lot of hands-on work. Is there a ratio of management duties versus manual duties that we should keep in mind?
There is not an exact, at least at the federal level, there's not an exact ratio. There have been some things over the years that is it 50-50, 80-20, you know, whatever, but it's a very individualized assessment. If that manager is truly hiring and firing his own employees and managing them, and he's also creating the budget for his department, so that he is doing all these managerial tasks, and he also pitches in when he's short-staffed, then he may very well qualify. But if it's truly a working supervisor who happens to be on the night shift, but he doesn't have those true bona fide department managerial duties, then he would not.
And you also see that, oh, sorry, I didn't mean to interrupt you, Tricia, but you also see it a lot in very small businesses where everybody's wearing every hat there is. So not only are you, like, you know, responsible for pricing your entire line of business, but you might also be cleaning out the bathroom at the end of the day.
Is there an exception for, an exemption for the number of total employees in your company?
No.
Nope. Unfortunately, it applies to all private employers.
Okay.
And just on that point, just to clarify that, again, the intent of the law from its very inception has been to pay all employees for all of the time that they work, and anything over 40 hours, time and a half. That's intended to apply to all of us, but they've just recognized that over time there's certain positions for which that's not feasible. But that doesn't relate to the size or the industry or the profit or nonprofit status.
Okay. If a person is making at least $913 a week, why do you need to look at exempting them?
It goes back to the duties piece. Keep in mind, even though the salary piece is getting a lot of attention right now, the salary piece has always only been one part of the puzzle. You could have someone that you're paying $90,000 a year to, but if their actual duties do not meet the criteria in one of the recognized exemption categories, they still legally do not meet the definition of exempt in order to be denied overtime pay. So you still have to, the duties are arguably the bigger piece of the puzzle. It's just that the salary piece is getting a lot of attention right now because it's jumping up so much.
For example, if you were working for a large company and you were a bookkeeper and you were making, you know, in a large metropolitan area, $50,000 a year, but you're working, say, 50 hours a week, if just because you're making $50,000 a year doesn't mean that you shouldn't be eligible for overtime, because the duties, the responsibility, the level of authority and responsibility in the organization that you don't have within the organization. I probably just confused that. Sorry.
Another question, does salary include bonus? So for example, if you are paid $40,000 a year and get a $7,500 bonus, does that keep you under the threshold?
That goes back to that 10% issue. It's only if the bonuses are non-discretionary. So those would be commissions based on sales, productivity, those kinds of bonuses. They could only be non-discretionary, and the bonuses amounts have to be calculated quarterly, at least quarterly, and then the true up, if the person falls below, the true up has to be done on the first pay period of the new quarter. So you couldn't do an annual bonus just because that 10% requires you to at least quarterly. And then whether or not you could even use that $7,500 would also depend on what the criteria for the bonus was and whether it was truly non-discretionary or if there were discretionary elements. Because if it was partially a discretionary bonus, then you couldn't use it to make up the difference at all. Only the true bona fide non-discretionary, if I know in advance, if I do X, then I will get Y based on this formula. Only those types of things can be used in doing a shortfall.
And even if you do have a valid discretionary bonus or non-discretionary bonus that's significant, you cannot pay them a salary of any less than $42,728. So that's absolutely the minimum you can pay them to have them exempt. And then the bonus would have to be well over that and non-discretionary.
Correct. The salary the $913 per week can only be reduced by 10%, no more than that, no matter how much their bonus might be.
Okay, great. Can you briefly go over the professional exemption?
Oh, I don't have it up. Charlotte, do you have it?
Yeah, well, there are two types. There's a creative professional, which we won't get involved in, and then the other one is the learned professional. And basically, what that means is positions that are largely the experience and the skills required for the job are largely obtained through a prolonged course of higher education. Might qualify as a professional exemption. These are your attorneys, attorneys are lawyers, doctors, accountants, engineers. It's possible that you could learn some of the skills in on-the-job training, and it's possible that some people have risen through the ranks in some of these positions via on-the-job training, but the vast majority of the skills and education obtained for that position are traditionally obtained through prolonged higher education. Trade school, vocational, like electricians, carpenters, that does not count as higher education. You're truly thinking university level for that exemption.
And again, I would encourage you to Google DOL Fact Sheet 17 or DOL Fact Sheet Professional Exemption, and you'll get the fact sheet on that.
And the other piece of the professional exemption is a creative professional, which covers things like actors and musicians, etc. So that word professional is not necessarily what a lot of people are thinking.
Let's see. We have a field service rep for pest control that are paid commission based on their route dollar amount. Will we be affected by this?
If they're exempt currently, they will have to be paid at least a minimum of $42,728 and a non-discretionary bonus. That sounds like a non-discretionary bonus of at least $821.70.
But
so,
thinking of positions like that, I would have my doubts that they would qualify as exempt if they have a route and that they are treating properties that's probably not going to be an exempt position. So they would probably have to be, you could pay them salary, but then they would have to be eligible for overtime as well.
Yeah, because when you think about that, it doesn't fit into the administrative, executive exemptions, any of the exemptions we've talked about. It doesn't fit in there. It doesn't sound like it.
All right. We have a seasonal business where office employees work hours during approximately half the year and are scheduled for short work weeks during the other half of the year, in theory, to offset the overall time. Can they still be paid salary with some sort of OT compensation during the high season? You were correct in stating that changing these employees to hourly would not be received well. Any suggestions?
Charlotte, you want to tackle that one, or you want me to?
Yeah, I didn't hear the beginning part of the question. It cut off.
So they have seasonal employees, and so sometimes they make and then sometimes they have periods of time where they don't make a lot of money. Is this going to affect them? And that changing them to hourly would probably, or to non-exempt, will be a challenge. The answer to that is that in any pay period throughout that year, if they're earning less than the minimum, they cannot be treated as exempt. So to keep them exempt, if they satisfy the duties test, if they're satisfied, if they are truly performing the function of an exempt employee, they would need to at least be paid a minimum every week, every pay period of that $913 in order to be able to continue to be exempt.
Yeah, unfortunately, the law doesn't allow for averaging that out. Each week stands alone.
Okay, great. Exempt employees are not typically required to track hours worked, are they? If not, then how would one correct a misclassification and pay treatment without the 2 years of hours record?
Well, one of the things that a lot of clients are doing now is they're having their potentially impacted employees track their time. For one, it allows the organization to get a feel for what people are truly working and to get some sort of baseline to determine what their hourly rate should be. But if you find that you've got someone who is misclassified, the Department of Labor would tell you that you probably, if you found out they were misclassified, you should go back and figure it out and pay them for any missed overtime. To be honest, I don't see anybody doing that. I see people, they're realizing the issue now, they're correcting it, and then going forward, treating them as non-exempt. Where there lack records on time, if an employee has said, well, this is what I work every week. I work 9 to 6, and I never take a lunch, and I can show that I never take a lunch because there's emails coming off my computer all day. Don't underestimate what your employees have and that they know what they're working. So if you don't have records on it and the employee does, then the Department of Labor would very well take the employee's records on it. But there are ways to demonstrate, no, we start at 8 o'clock, we leave at 5 o'clock. There are definitely ways to do it, but the honest truth is I'm not seeing anyone go back the 2 years right now. They're correcting it going forward. It's a risk, but I'm not seeing anyone do it.
And typically the important thing on that is that the courts generally favor the employee, because if you misclassify them, the error is on you. And so if it's sort of a he said, she said in terms of responsibilities or in terms of time, there's no way to prove it, they're probably going to, at least in part, favor the opinion of the employee because it was a mistake if it turns out they were misclassified. So again, sort of an area of caution.
And of course, misclassification isn't a concern for the previous 2 years if the employee historically does not work overtime. It's only if there's overtime involved that it becomes a real concern.
Another question that we have, we do have inside salespeople, non-exempt, who occasionally travel for work. Are there rules for what period of time away they will be compensated for? Can we compensate them for the actual time they're meeting with customers, or do we need to pay them for the actual travel time, etc.?
I was just going to say, Charlotte, that on questions like that, I think we might want to talk with you offline, because you need to look at the specifics of what kind of travel, how much time, how far away, the position that they normally have. So that might be a good, we might want to talk about that.
If that individual wants to reach out directly, we can go through that, because what counts as time worked for travel is very specific, and it even matters whether or not it's same-day travel or overnight travel. So it would very much depend on the individual example.
We're at a few minutes past 3, but I'm happy to take a couple more questions if that is okay with everybody online.
Yeah, there's just a couple more questions that I think would be worth talking about. If you have an employee that meets the duties test for one of the exemptions but doesn't necessarily have the salary to be exempt, should the admin make the employee an exempt employee by increasing their salary, or make them an hourly employee?
Well, that's truly the choice, right? So that gets right to the nub of the issue. I think that what we've seen our clients do, if they satisfy the exemption in terms of their duties, and they're, again, within spit and distance of that new 47,476, then they are likely bumping them up above that threshold. If it's such a financial hurdle to get them up to that level, then they're reclassifying them as non-exempt and either paying them on an hourly or a salaried basis.
What would be the common pitfalls for employees who leverage hourly team leads in a manufacturing or production-based environment? What would be the common pitfalls for employees who leverage, oh, sorry, it was just copied and pasted twice. I thought it was a 2-part question.
Can you read it one more time?
Yeah.
It's because I knew I needed to hear that question twice.
What would be the common pitfalls for employees who leverage hourly team leads in a manufacturing or production-based environment?
What would be I think I don't understand the question, because if they're managing hourly team leads, if they're hourly and they're treated as non-exempt, then they're tracking their time, and so it's really an issue of managing time and attendance and being liable for overtime. Charlotte, do you have a different take on that question?
No, because I'm not quite sure what it's asking either. I mean, certainly you're looking at the individual for, are they actually managing the department and the individuals and hiring and firing those individuals, or are they right there doing the production work too, and they happen to kind of be the contact point, the go-to person on the shift, So I think that would kind of depend more on what the individual situation is.
Okay. If the office is closed due to inclement weather and an employee states they worked on items at home on that day, must they be paid for their hours worked?
So yes, and this is one of those points that we mentioned, that understanding what is compensable time, if you're now having to track the hours and pay the hours of non-exempt employees, if this is new, there is a lot of work that typical exempt employees do at home during inclement weather, on their cell phone, while they're commuting. All of that time, if it's work done on your behalf, is compensable, needs to be paid and tracked, and can contribute toward that overtime in the course of a year. So, or in the course of a pay period, toward that 40 hours a minimum. So, yeah, they do need to be paid, and you either need to figure out a way to track that, or need to have some sort of a reporting on their behalf to be able to factor in all of that time. Because going forward, if they're not exempt, all of that time is compensable.
Or kind of like the unauthorized overtime, I'm seeing a number of employers are saying you are not permitted to work. If you're not here, you know, you're not permitted to work, and then if they do work, yes, you have to pay it, but it's still a disciplinary issue. And when you think about it, it wasn't that long ago where we went to work Monday through Friday, 9 to 5. We came home, we didn't have cell phones with email and stuff coming through. So I am seeing a fair number of businesses go back to that.
Yeah. Yeah. A lot of new policies are getting put in handbooks about how to handle.
You just have to set up the expectation of what is acceptable and what isn't, and what the parameters are, and start managing to them, both from a payroll perspective and a management perspective.
Great. Tricia, I'm mindful of your time, and I know we're limited here. We're about 7 or 8 minutes over our time. What I want to say, those of you who still have outstanding questions, please reach out to us. We're happy to help. We're here. We're offering some discounted consulting time. You can schedule some time with us through the site that's on your site. We're also going to be following up with this. We have recorded this video, and that will be located again on our YouTube channel station, and we will be in our follow-up email to you. We will be sharing a link. If any of you would like this actual slide deck, we're happy to share it with you. Please just send us an email, reach out to us. You see it's contact@affinityhrgroup.com. That's our main email. You can reach either Charlotte or me by our first names at Affinity HR Group. So Charlotte at Affinity HR Group or Claudia at Affinity HR Group. We're truly appreciative of the time that you've spent with us, and obviously this is a big issue. This is one of the largest webinars I have ever attended, and certainly ever delivered. So there are a lot of questions that remain, and we are here to help as much as we can, and we'll see if we need to conduct another one of these. But if we haven't answered your question, please reach out to us. So many thanks, Charlotte, and I'm going to just pass that right back to Tricia.
At this time, I would just like to give a warm thank you to our presenters for sharing their content with us today, as well as to everyone in the audience. Like Claudia said, a recording of this webinar will be made available within the next business day. We thank you again for attending today's webinar. Have a great rest of your day.